Hi, this is Lisa DeMonte with mylegal.com. We are here in Washington, D.C. on Friday, May the 7th, at the second annual National Institute on Internal Corporate Investigations and Forum for In-House Counsel. With me this afternoon is Jonathan Sack, who's a partner at the firm of Morvillo Abramowitz. Morvillo Abramowitz. Thank you, John. Thanks for joining us this afternoon.
My pleasure.
John, you were part of a breakout panel on the topic of representing an individual in an internal investigation. And there were a number of topics discussed during that panel, very enlightening conversations and lots of interesting topics for sure. Some of those topics included conflicts of interest, disclosures by company counsel to employees in interviews, obligations to employees who incriminate themselves, and there was mention just briefly about the U.S. versus Stein case, but there really wasn't a whole lot of discussion about that. Can you share with us your thoughts about how the U.S. versus Stein case relates to the panel discussion that you were involved with today?
Yes, sure, I would be glad to. The U.S. against Stein case involved a situation where the government used very, very heavy-handed pressure on a company that was cooperating with the government, an accounting firm actually, KPMG, pressuring the company to deny contractually obligated advancement and indemnification of fees to individuals, and saying to the company if it wished to cooperate, it needed to pressure, it should tell employees that payment of fees would be denied if individuals did not fully cooperate with the government investigation. And what the court in the Southern District of New York, Judge Kaplan, ruled, among many rulings, was that the government's conduct through the company to limit and in many cases terminate the advancement and indemnification of legal fees amounted to a Sixth Amendment violation, a denial of the individual's right to effective counsel. That decision was affirmed by the Second Circuit, and the case was ultimately dismissed as to those KPMG defendants who suffered in the way the judge described. There were some defendants who were not affected in that way, and the trial went ahead. What the case really stands for is that government may not interfere with obligations of a company to advance and indemnify fees. And what the decision really led to was a modification, at least on paper, of Department of Justice policy. Previously, policy said the government would look into the advancement of fees in deciding whether a cooperation should get credit for cooperation. The policy was changed to remove that consideration. The interesting questions now relate to whether those changed policies will lead to changes in DOJ practice and whether it will lead to a full recognition of individuals' rights to indemnification and advancement. So overall, the Stein decision has led to greater awareness and greater appreciation of the importance of individuals having the funds necessary to defend themselves in complicated white-collar investigations. Thank you, Lisa.
Thank you very much. Again, Jonathan Sack from Morvillo Abramowitz.
Thank you.
Thank you, John.